Gender Inequality in Corporations by Kristen Casanave, Connell Johnson, Jayla Graham, and Emily Rochelle. Over 50 years ago, the United States Supreme Court made it illegal for employers to discriminate based on race, color, religion, sex, or national origin. However, our corporate culture has failed to put bias and stereotypes to rest. Throughout this semester, we have discussed several different laws that pertain to employment discrimination. These include Title VII of the Civil Rights Act of 1964, prohibiting employment discrimination based on race, color, religion, sex, and national origin. The Age Discrimination in Employment Act of 1967, or ADEA, protects individuals who are 40 years of age or older. There are more specific anti-discriminatory laws listed below. The Equal Employment Opportunity Commission, or EEOC, processes all of these allegations of discrimination. I will talk about these laws in depth later in the presentation, but first it is important to know why there is discussion today about gender inequality. Achieving gender equality is important for workplaces not only because it is fair and the right thing to do, but it is also vitally important for business productivity of our nation. This is because gender equality provides employers a larger selection of the top talent, and it improves productivity and competitiveness, it creates a diverse environment, and brings in different ideas. Even though gender equality achieves these important qualities of a business, discrimination is still a huge issue in corporate America that needs to be addressed. As more and more individuals identify themselves as transgender, legislature will be forced to recognize them as a protected class. It is a necessity that Title VII be amended to keep up with society. An example of the irony in transgender inequality is the Jamal versus Saks Fifth Avenue case. Ms. Jamal was subjected to a hostile work environment at the Saks department store in the Houston Galleria when she was employed there in 2012. The harassment was typical and brutal, routine misgendering, forcing her to use the men's room, and was ridiculed by her coworkers. The EEOC is on board with the movement. They concluded that Ms. Jamal was in fact subjected to intimidation and harassment based on sex because she failed to match the male stereotype. But Saks Fifth Avenue essentially claimed that transgender people shouldn't have protection from discrimination in the workplace because they are not a defined protected class under Title VII. This is an issue that is not going to be resolved unless our society continues to talk about it. However, on May 28, 2014, Mayor Annise Parker, the first openly lesbian mayor of a major American city, with the help of the Houston City Council, extended equality rights to gay and transgender residents. It states that no Houstonian should be discriminated against based on race, age, pregnancy, religion, military status, sexual orientation, or gender identity. The Houston Equal Rights Ordinance is a small step into the right direction, but some of the country's largest businesses have actually transgressed. The following cases are just a few examples of where our nation currently stands on gender equality. The Gruszewski versus Hooters case is a unique one because of Hooters' defense mechanism. Blocked from a job serving food and drinks in a Hooters restaurant, Nikolai Gruszewski filed a proposed class action complaint accusing Hooters of America Incorporated of unfairly denying men waitstaff positions. Gruszewski filed the complaint in the U.S. District Court of the Southern District of Texas after being denied a job as a server at a Hooters restaurant in Corpus Christi, Texas. Hooters used the strong defense of bona fide occupational qualification, or BFOQ, which applies when the essence of business operation would be undermined if the business eliminated discriminatory policy. That is just one example of defenses that corporations are using to avoid liability. Ellen Powell is another example. Powell was an employee of Kleiner Perkins, a large venture capital firm. In her case, she argued that men were promoted ahead of women, that women's ideas were more often dismissed, and that women who experienced sexual harassment received little support. Powell claimed that Ajit Nazra, the partner who initiated a sexual relationship with her, was responsible for much of this harassment. She also mentioned that he began excluding her from important meetings and emails after she ended the relationship. This court case inspired many other women working in high-profile companies to speak out and bring lawsuits to the table. A number of publications credited Powell and her case with focusing attention on the issue of gender discrimination and workplace sexism. The impact of Powell in the case became known as the Powell Effect. Payal Kumar is the author of the book Unveiling Women's Leadership, Identity and the Meaning of Leadership in India. Her book illustrates the continued lack of women in high-ranking positions in large corporations. She also quotes American novelist Fannie Hurst, "A woman has to be twice as good as a man to go half as far. In her opinion, the Powell case shows the impact of sexual discrimination in the progressive field of technology. Merck & Company Incorporated was also in hot water. In May 2013, Kelly Smith filed a class action lawsuit in New Jersey federal court alleging that the pharmaceutical giant Merck & Company Incorporated discriminated against females in its sales force through pay and promotions. Despite her skills and qualifications, Merck allegedly discriminated against Mrs. Smith because of her gender and pregnancy leave by denying her promotional opportunities, disciplining her unfairly, giving her unfair performance evaluations, and subjecting her to other discriminatory actions that have stalled her career and harmed her professional reputation. Ms. Smith was also paid less than similarly situated male employees and demoted upon returning from maternity leave. Ms. Smith was informed by her superiors at Merck that the decision to demote her as well as deny her an award was due to the timing of her baby and maternity leave. Unfortunately, the corporation won the trial against gender discrimination due to the class not having a specific common discriminatory act to use in trial. The Supreme Court noted in Walmart, which I'll discuss later, that one of the ways to bridge the conceptual gap between an individual's discrimination claim and that of a class, and therefore justify class certification, is by showing significant proof that an employer operated under a general policy of discrimination. The next inspiring case is Dukes versus Walmart. Betty Dukes, a female low-level Walmart employee at Pittsburgh, California, with 5 other women, filed a class action against the alleged violation of civil rights by the company. The allegation was that the company's policies resulted in nationwide discrimination against women in their employment. They were paid less than men working the same job, and male employees were often promoted before women. The class had more than 1.5 million women, all of whom were women employed by Walmart after December 26, 1998. Walmart argued that the court should require individual lawsuits from Walmart employees as the size of the class made it impossible to manage and increased the costs disproportionately. The court found that Dukes failed to prove that all members were subjected to the same discrimination based on employment policy, and therefore her case did not fulfill the criterion for commonality of fact or issue. Although Dukes lost the case, John M. Husband and Bradford J. Williams believe it will prevent future class action lawsuits of similar sizes. Most scholars, like Husband and Williams, believe the failure of Walmart Stores Incorporated versus Dukes has now set a precedent for future class action lawsuits involving Title VII, which will make it easier for corporations to avoid similar incidents. Deborah Thompson Eisenberg says that laws need to be remedied to fit how wage discrimination occurs in the modern workplace. She explains that the wage gap is usually created by pay systems that leave control to individual supervisors, such as Walmart's compensation scheme. Eisenberg suggests implementing incentives for self-regulation would correct these policies. There are also difficulties caused by prima facie standards of equal work under Equal Pay Act of 1963. According to the EEOC, if the jobs to be compared share the same common core of tasks, consideration should be given to whether the jobs require substantially equal skill, effort, and responsibility, and whether the working conditions are similar. Holly Carr from the American Association of University Women has an additional opinion on the potential implications from the results of Dukes versus Walmart. She believes that Dukes emphasizes the importance of appropriate class action suits against discriminatory employers as a deterrent to other employers from engaging in similar practices. According to the U.S. Equal Employment Opportunity Commission, over the previous 17 years, the number of sexual discrimination cases in the United States has stayed remarkably consistent. This indicates stunted progression towards absolute gender equality. It is important for us as rising leaders of this country to continue to talk about gender inequality. We need to be cognizant of continuous change of statutes and voice our opinions along with it. Emphasizing this topic to the younger generations is important to show how to respect people in the workplace instead of discriminating for various reasons. History has influenced how people view certain topics, and we need to teach that not everything in the past is correct. Thank you so much for listening.